Now to our coverage of the landmark Supreme Court decision overturning Roe v. Wade today. Tonight, we're looking at the history of that case from 50 years ago. Anthony breaks down the timeline.
We want to talk a little bit about the history of Roe versus Wade. So let's start in 1970, March 1970 to be exact, where two attorneys filed a lawsuit in U.S. federal court on behalf of Norma McCorvey, a Texas resident who wanted to terminate her pregnancy. The filing, Jane Roe versus Wade, argued that Texas's abortion statutes were unconstitutional and violated McCorvey's privacy under 5 constitutional amendments. Then in January of 1973, a 7-2 Supreme Court decision in favor of Jane Roe rules that the Constitution protects the rights to an abortion. The all-male justices found abortion was a, quote, fundamental right for a woman's life and future. In September of 1976, the Hyde Amendment, a restrictive measure prohibiting government funds to be spent on abortions, except in the case of rape, incest, or a threat of life to the woman, that was passed. Let's go to 1988 now and 1989. Lawmakers in Pennsylvania amend the state's Abortion Control Act of 1982, adding 5 provisions, including informed consent before an abortion, a 24-hour waiting period, consent of one parent for a minor to have the procedure, and a husband notification requirement for married women. Then in June of 1992, Planned Parenthood of Southeastern Pennsylvania versus Casey. The Supreme Court's 5-4 decision upholds the 3 provisions. The court did invalidate the husband notification requirement, however. Then in November of 2003, President George W. Bush signs into law the Partial Birth Abortion Ban Act, prohibiting doctors from performing late-term abortions. Then in April of 2007, the Supreme Court upholds the federal ban on late-term abortions, ruling 5-4 in the Gonzalez versus Carhart case, finding that it was not unconstitutionally vague and did not impose an undue burden on the right to an abortion. In July of 2013, Texas lawmakers enact House Bill 2 with provisions that include requiring doctors performing abortions to have hospital admitting privileges no more than 30 miles from the abortion facility. Abortion providers in Texas challenged the requirements, arguing that they violate the 14th Amendment under Casey. This challenge ultimately ends up before the Supreme Court and is struck down in June of 2016. So, June of 2016, the Texas Admitting Privileges and Surgical Center Requirements law is struck down by the Supreme Court in a 5-3 ruling. Then in May of 2021, the High Court agreed to hear Dobbs versus Jackson Women's Health Organization case, the Mississippi law that bars abortions after 15 weeks of pregnancy. Later, Mississippi state leaders would ask the Supreme Court to overturn Roe and Casey. September of 2021. Texas enacts Senate Bill 8, that's also known as the Heartbeat Act, the first time a state successfully imposed a 6-week abortion ban since Roe versus Wade. The act also gave members of the public versus state leaders the right to sue anyone who performs or helps facilitate an illegal abortion. The Department of Justice challenges State Bill 8, and in December, the Supreme Court ruled to keep Texas's ban on most abortions in place, limiting who can sue state officials. Now, on May 2nd, a 98-page draft opinion written by Justice Samuel Alito in the Mississippi abortion cases leaked. Justice Alito wrote in his draft that Roe was egregiously wrong from the start and, quote, must be overruled. Now that the court has overturned Roe versus Wade and Casey, a woman's right to an abortion is now left up to each state unless Congress steps in and passes a national policy.